tracks were like this big. They were like that big, and you shoved one in to play. It was cassette tapes. There was these big 8 tracks. Yeah, yeah. You need a lot of space for those. So. Look what you did. One sentence out of you, and we're down the road like squirrels. Broke the internet evidently. So,
Oh, we can. Okay, we'll wait.
You'll be relying on my superior hearing.
We can wait.
It's fine. I've got my hearing aids in, and right now I can hear everything pretty well. Check 1 2. Testing 1 2 3. Check 2.
Test, test. Is everyone good? All right.
Thank you. I got it. Thank you.
It is 7:09 p.m. Please rise for the Pledge of Allegiance. All right, on to roll call. Mr. Kirschner. Oh. Mrs. Dottleberger.
Here.
Mr. Bauer here. Mrs. Gray.
Here.
Mrs. Walsh.
Here.
Mr. Kirschner.
Here.
All right, on to item 3. I would like to recommend to accept Latoya Dowdellberger as treasurer pro tem for this board meeting.
I'll second it.
Any discussion? On to roll call. Mr. Kirschner.
Aye.
Mrs. Dowdellberger.
Yes, aye.
Mr. Bauer, aye. Mrs. Gray.
Aye.
Mrs. Walsh.
Aye.
All right, motion passes. On to B, adoption of the meeting agenda.
So moved.
I will second. On to a discussion.
1 second, just if we
Yep.
could, with like I said last time, I guess with me being treasurer pro tem, if I could have just a few moments in between to catch up. So you were first, Mr. Bauer, for the adoption of the agenda.
It was Mrs. Gray, and I
Okay.
seconded it.
Thank you.
Yep. Okay. Yep. It's okay. Any discussion?
Roll call.
All right, on to roll call, please.
Mr. Kirschner.
Aye.
Mr. Bauer.
Aye.
Ms. Gray.
Aye.
Ms. Walsh.
Aye.
And Ms. Dowdellberger. Aye.
Motion passes. All right, on to C1, board policy review. And we have 2 policies here. We want to start with IGBLA.
Okay, so IGBLA, originally OSBA sent us 2 sample policies asking us to choose one. There was an update in June that we had not noticed prior to the last meeting. So there wasn't any more choose one or two. It was their current sample policy, and that's what is attached to the board meeting tonight.
Are we going to vote on each one separately?
Yes, correct. So
Okay.
we need a motion.
I'll make the motion to approve policy number IGBLA as presented.
Okay. So the first is you made the motion, Ms. Gray.
Yes.
Okay, so we need the second. Okay.
Do I have a second? I will second. On to discussion. Hearing none, on to roll call.
Wait.
Well, wait, a minute.
Oh, sorry.
I wanna, look at this real quick, which one there were two versions, right? Or was there just the one?
This one had just the one, and this is the one from the June update, correct, Superintendent?
Correct. Mrs. Walsh, you are correct that originally there were two options. Were recommended select one or the other. In the June update, this is the model policy that they brought forward. So there wasn't any option choice in this particular one.
And this is just taking what we discovered at the last meeting, those changes, correct?
Yes, that's correct.
And just give me a minute. I just want to make sure I get James' comment about the update from the June. So you guys can keep talking, but I do need a minute to finish this note. Thank you.
Is there any other discussion on this? Okay.
Thank you. We are on, subject C, cell phones, correct? No, I'm sorry.
No, we are on IGBLA.
We're on the first one, promoting parental involvement policy.
It's listed together with the cell phone policy, but we're separating them out to vote separately.
Thank you. I got totally so lost.
Okay.
All right, thank you.
Did we review any of these policies in our parental advisory committee? This particular policy at any point?
No, we have not.
Okay, thank you. What, I'm
As with for that, I mean, we can definitely reevaluate now that when it came up in our June meeting, this was after this review or request to review was after, I believe. So we can definitely, is that correct, Ms. Gray?
Yes, that is correct. It was after our parent meeting.
So what we
That
can
came out.
do, we can definitely, be in compliance with the July 1st. And if my colleagues would be open to it during our parent advisory, add that as a conversation in our July meeting if we need to make any or hear any additional recommendations. But that is something that could be discussed.
We have Mr. Morbister here tonight, and Mr. Morbister is going to be working with us on policy. Mike, do you have anything you'd like to comment on this first policy?
I do. On this first policy, I have just one minor recommendation that's on the third page. It's in a section that is entitled Concerns and Appeals Procedure. There are multiple paragraphs. In the second paragraph, it starts with a parent may appeal a principal or assistant principal's decision. This is, again, a minor recommendation for this first policy. It's at the end of the paragraph. The last sentence reads, if the superintendent does not affirm the decision, they determine the resolution to the parent's concern. My concern with that is that in an attempt to be gender neutral with the pronoun they, it might produce some ambiguity with who the they refers to. So it's a pronoun and antecedent issue. What I recommend is doing what has been done throughout this document, especially as you see in the next paragraph. Whenever a case of ambiguity comes up, they just restate who's being talked about. So in this case, the sentence would read, if the superintendent does not affirm the decision, the superintendent determines the resolution to the parent's concern. That would make it clear and clear up any confusion, because in the previous sentence, principal and assistant principal were also mentioned. So someone may think that the word they refers back to one of those two positions.
And where exactly are you at again?
So on the third page, it begins with the section is Concerns and Appeals Procedure. There's a first paragraph and then a second paragraph. The second paragraph begins, a parent may appeal a principal or assistant principal's decision to the superintendent. What I'm focusing on is the end of that paragraph. The sentence is, if the superintendent does not affirm the decision, they determine the resolution to the parent's concern. I'm recommending the sentence to read, if the superintendent does not affirm the decision, the superintendent determines the resolution to the parent's concerns. That would just clear up any ambiguity with that pronoun they.
I will modify my motion to include that change. If I can have a second.
Yep. I will.
One further point of clarification, since we're talking about this a little specifically. Most of the time, I think in our language, if it says superintendent, it says superintendent or his or her designee, depending on the situation. If it's appropriate to swap that out, because I might not always be the person directly involved with it. A lot of times people are doing investigations on my behalf.
That is a good point. I would modify it to that.
Okay, then I'll second that.
I just have to give me a second so I can capture what Mike stated. I have part of what Jamie, and I have the two modifications to the motion now reading the they to superintendent, and then the other one was the to superintendent or designee, correct? Thank you.
Yeah, I'm still not exactly sure where you're talking about. I know it's in the concerns and appeals.
Right.
Mhm.
Or it says they. Or superintendent's designee.
If I understand correctly, bottom of page, bottom of third page, concerns and appeals, second paragraph, the superintendent is asking that we change it to if the superintendent insert or designee does not affirm. Is that correct?
So I was actually looking at the very first line of that same paragraph. A parent may appeal the principal or assistant principal's decision to the superintendent, I'll say, or designee at that point, because then it goes on in that same paragraph. If the parent appeals to the principals or the superintendent / designee, I think this is just things that they left out of the language and the edit that should have been there, but to clarify from the start, I think the rest of it is fine after that.
You don't want, good, because I was getting hung up on that.
No,
you don't want designee in the final sentence where it says,
no,
because
correct.
you have to affirm. Correct.
Yes.
Okay, thank you.
Yes.
I got it. All right. I was getting concerned about that. Thank you. And then the third sentence is fine the way it reads, correct? If a parent appeals the superintendent's decision.
The only change in that is instead of saying they, it says the superintendent determines to clarify who the decision maker is.
That's on the final sentence in the second paragraph.
In that final sentence.
Okay. Thank you.
And what paragraph was that? I just want to make sure I have it in the notes, please.
Yep, it's paragraph 2 under concerns and appeals procedure, page 3.
Concerns and what was the other part? I'm sorry.
Concerns and appeals procedure.
I'm a little concerned about the first paragraph, the last sentence, anonymous. Oh, I'm sorry, you're not ready. Are we ready? Can I go ahead?
Not really, but it's okay.
Okay,
Go ahead, Miss Kathy. It's
Let
okay.
me know when you're ready. Let me know.
No, I have enough so I can pause. I'll just need a minute. So I was actually going to go through here to make sure I'm matching up what I have typed. So go ahead and I'll just grab your comment. You can go ahead. It's okay.
Okay, the anonymous written concerns may not be investigated. So is there a reason why we would, a lot of parents
Can you share where
call
you,
me and
Miss
they don't want to let anybody know because who they are because they're afraid of retaliation. So if it's an anonymous written complaint, it's kind of like a whistleblower thing, I would think that we would, and it says may, it doesn't say shall, so are we picking and choosing? I don't know, I think that should probably come out.
Mr. Morbitzer, do you mind commenting on that?
What section are you referring to, please?
This is
The first paragraph under concerns and appeals procedure, that's, I guess, page 3. We don't have page numbers, but it would be sheet 3. The very last sentence of the first paragraph.
So that line, anonymous written concerns may not be investigated, is in alignment with other policies that the board already has, including public complaints about personnel. Anonymous complaints are not investigated in other parts of the policy. If you're going to do that, you probably want to look at a lot of other policies that disallow anonymous complaints. And in this case, we want to encourage people to identify themselves so that an investigation can be properly conducted.
So my question is, how does that align with our whistleblower policies?
Well, whistleblower policies would align with that because the whistleblower policy protects people who are identified. Whistleblower has no point in identifying or protecting people who are anonymous.
That's the whole point of whistleblower policies, is to protect those that identify themselves.
Yes.
Doesn't our whistleblower policy allow for anonymous complaints?
I'm not aware of that. I know that another policy, particularly the policy about public complaints about school personnel, disallow anonymous complaints. They are not investigated.
And don't we have a hotline for whistleblower complaints that say you can remain anonymous?
I'm not aware of that.
I believe we do. Isn't it on our website? I'm pretty
Yeah,
sure.
so it says students and adults can utilize. I believe we have a tip line in our manual for anonymous reporting of threats to student safety or other issues.
Isn't that the state
All right.
whistleblower or state, not notification system?
I'm sorry, I'm on the wrong screen. Let me see if I can catch what you just said.
There is in this language an opportunity to allow for anonymous concerns to be investigated, anonymous written concerns. The operative word being may. Anonymous written concerns may not be investigated. So if you want to hedge your bets a little bit, that would be the way to keep that language. They may be.
Oh, I think we're talking. Are you talking about the Safer Ohio School Tip Line?
Yes.
Okay, so that I believe is through the Ohio Department of, the Education and Workforce.
So then the question becomes, if the Ohio Department of Education Workforce reached down to us with something that maybe they validated or they have a concern, we're putting in policy that we can't act on that.
Mr. Smathers?
This has unfortunately happened a few times, and every time they call me, they give me the information, the names, phone numbers, so I can contact and investigate.
So far,
I haven't received an anonymous tip.
okay.
So I believe, I would move that we remove the anonymous written concerns may not be investigated language.
Miss Walsh, can you, okay. You
Yep.
said what your motion is to remove?
That's the language.
Mhm.
Anonymous written concerns may not be investigated. Be removed from the policy IGBLA that we're considering right now.
Do I have a second?
Second. I just want to throw an example out. So let's say you get an anonymous complaint from a student that is afraid of retaliation, etc., or anyone, and with the complaint is ample photo evidence, everything you need to know that it's valid, right? You can look at it in 5 minutes. You can go into a room or whatever. You can know that this happened, or maybe it's a video of the event, and we're just saying, hey, you don't want to put your name out there, so we actually just can't do anything about it. We're actually tying our own hands to where we could have somebody did really bad, and we're putting down a policy that says, yep, sorry, we can't act against that bad actor. I think that causes me concern.
Well, number one, I don't think you would ever get everything you need to know in the investigation, and there's no way to follow up with an anonymous person. The other thing is, other things that could happen. There could be wild, false claims made against people. There's no way to follow up with the person. There's no way to get detailed information, and people have rights that they can't just be accused of things without a fair shake and due process. That's the other side of that same coin.
Yeah, I understand that.
Well,
There are
I would,
certainly, I think there would certainly be scenarios where there would be enough information provided that we would know something was wrong. The video would be a great example. I don't know how a video of an event, if it was, okay, so let's just say this. Let's just say someone posts a video of an event anonymously on Facebook, and we can see the entire event now, and staff is involved, and there's something bad. We're saying, oh, sorry, nothing to see here, till somebody comes forward with a name, and I guess that would then, in that case, could anyone grab that piece of evidence and claim it as their own?
The way I read it, it says may. So to me, it says anonymous written concerns may not be investigated, which still allows us the opportunity to investigate if it's deemed necessary. That's how I read it.
Well,
Same here.
the way I see with if it's a wild accusation and there's no evidence, then that investigation would be pretty short, like minutes. Like, okay, there's no evidence. There's no way we can investigate this. I think John's example where there is ample evidence is why it should be that you investigate it. The may means you could have evidence and decide, I don't want to investigate it. We don't have the time. We don't have the resources. It doesn't seem that important what I'm seeing on the face, but when you dig deeper, it might be. So if there's somebody making wild accusations with no evidence, that's going to be a very, very short investigation because there's nothing to investigate if they don't have any evidence presented with their accusation.
I guess we're saying that the may not is giving us discretion. Since it doesn't say shall not, we're saying
Right.
may not gives us discretion.
Yeah, and when I just looked up like the legal term in
Yep.
policies and things like it generally signifies permission or discretion. So it's not taking it away. It's
Right.
just the facts, like you said. In that case, if there is this video, as you mentioned,
Right.
on Facebook anonymously of an event dealing with the school, it's clear we can see it. That could be fall under the May. That's a great example of where that would then fall under how the policy's been shared from our policy provider.
And mine might do it. It doesn't. But they're not posting every single thing that's out there that somebody is making claims about. It's like
Right.
you
You're
could
not
be
committing yourself.
spending their whole time doing nothing but investigations of anonymous claims.
You're not committing yourself to investigate everything you hear. Yeah.
Right.
All right. Any other discussion?
Give me a minute.
Okay.
And I think Mr. Morpiter,
Oh.
but I just need a minute though. So before you start, can you let me just finish this one sentence real quick? Thank you, sir. Ms. Gray, can you just repeat a little bit of what you just stated though, just so I make sure I have everything? Yes, ma'am.
Just that this protects us from not having to investigate every little accusation that's out there because they could spend, the administration could spend their whole days doing nothing but investigations.
Thank you.
Okay, I think I have a final point that may cement the board's discussion about the word may. It does seem very purposeful, especially in the sense of may or may not be investigated. Substitute the word will. How much would it change? It would change significantly, wouldn't it? Will not be investigated. That would clear it up completely. That's not what the board intends to do, I believe.
Right.
So the word may is important. I think it means may or may not, but the word may by itself also means or not, may or may not.
Thank you.
Okay, I'm ready. So at this point, we just finished discussion. Just to make sure I didn't miss anything for Mrs. Walsh's motion. Her motion was to remove the language of the, which is in the, on the third page under the concerns and appeals, first paragraph, last sentence, that reads, anonymous written concerns may not be investigated. And Mr. Kirschner was second on that.
That's correct. And on to roll call, please.
Okay, 1 second. Let me get my roll call thing ready to go.
Okay.
Just give me 1 moment.
Was the motion to remove, oh, okay, may not be investigated. Concerns may not. Okay, hold on. Give me a second, please.
Sure.
The motion was just to remove that one sentence.
Correct. That's what I had.
And- Right, I'm just letting Don know that. And with the other changes,
Oh,
were
so-
those a motion also?
Yeah.
That was in the first one.
That was in the first one. So after we vote on this motion, we'll go back to Mrs. Gray's motion.
Um, so I understand. Were you saying that we could change the language to may or may not?
You could elect to do that, but using the word may would cover that as well because
It
it's about
does,
the
but-
possibility.
Right, but when you what I'm seeing legally is when you copy it, when you couple it with not, it signifies a prohibition. You may not. So if we don't put may or may not, then we're saying you can't do it.
If you want to add that, that would be advisable. That would be,
Yeah.
that would allow for either contingency.
So, let me look back at the motion, please.
I can reread it, Mr. Kirschner.
Thank you.
No problem. The motion from Ms. Walsh was to remove the language in that the first paragraph under concerns and appeals procedures, which reads, anonymous written concerns may not be investigated. So that is the motion that we were currently discussing and was ready to do roll call for.
Okay. So if we want to vote on that motion, I would move for better clarity of language than that, which would be anonymous written concerns may or may not be investigated at the discretion of the district.
So Mrs. Walsh would need to modify that, correct?
Yes, unless Mr. Kirschner would like to do another motion.
Okay. So
Well, let me ask Mr. Kirschner before I make that change. How do you make the decision on may or may not? Who makes that decision? What is the criteria? I don't know how that change would be beneficial.
If you don't make that distinction, then I guess you take away all discretion and someone could make, um, let's read the entire thing. A parent may file a written concern with a school principal. Anonymous written concerns may not be investigated. So, um,
And my recommendation is to just remove that sentence.
If we read further down in that paragraph, if I might say, the last paragraph says the board directs the superintendent slash designee to develop procedures to ensure prompt and fair attention to written concerns about this policy. So
Could-
if
could-
we have
could-
the may language, then it sounds as if we could, we'll work with the superintendent so those are procedures, what that looks like, and see what he has, and the district notifies the parent. But if you're speaking to strictly anonymously, but it says may, we still have this policy grants the opportunity to do that, especially in the example Mr. Kirshner provided.
So I'm just having a little trouble understanding what you're saying here. It says the slice doesn't need to develop procedures to ensure prompt and fair attention to rank concerns about this policy. The closed caption is not doing very well, so can you restate, please?
I just read the last paragraph in the policy under concerns and appeals. The first sentence of the last paragraph.
Go ahead, Mr. Morber, sir.
I'd like to point out in the same paragraph that you were just referring to, it makes many mentions of to whom the parent makes an appeal. So the parent is vital in this. How can the superintendent be responsible or responsive to the parent if the parent is not identified? That's what this entire section is about. If the
Right.
parent
That
is not
makes
identified,
sense. That makes sense
okay.
to me. I can get that kind of.
no, but so here's the counter to that. So if you get a lousy complaint with no merit and no name, you got no worries. But if it's a credible complaint and you can see what you need to see, then it's up to us how we proceed because the parent cannot go any further in any of the steps. So we could still gain vital information through a written complaint. And we could still, if we chose to, if we saw something, I mean, I don't want to tie anybody's hands. We could get a complaint that Mr. Groove and Mr. Smathers and everybody wants to act on, right? And we don't know who it is, and that's fine because the parent has no say now. But we still don't have to throw it in the circular file just because they were worried about, and it's very legitimate that you could be worried about retaliation against your child, whether or not we have whistleblower or not. You know how many whistleblowers get fired after they blow the whistle, right? So, there is a reason that people would possibly do anonymous, but the flip side of that is, hey, they got no recourse. So it's totally in our court now.
True.
So it's
The
kind
parent
of
is
like
not
no
identified.
harm it's no harm to us if they do anonymous and they have no rights to go forward.
So your concern is on the end of the sentence about being investigated.
Right.
So
Like
it's at the
we
discretion of,
see something totally, you see Jack go out and light a bus on fire, and somebody witnesses, but they're afraid of Jack, and they give us the video, and we go, sorry, we can't investigate Jack because we wrote this in a policy, and we don't know who gave us that video.
But that's not what we're talking about. We're talking about parents' rights.
yeah, the entire section
It's,
is about the
it's
parent's
with
appeal.
their student, with their child.
Right,
We're not talking about other types of incidences that
Okay, right.
the community's bringing up.
Yeah, that was the same point I was going to make, Libby. This whole section of policy is parent involvement, and if you look at where we're talking concerns and appeal, if you look at the first 3 paragraphs, a parent may file, a parent may appeal, a parent may appeal. If it's anonymous, we don't even know if it's a parent. We don't know if it's a resident. We don't know if it's a student. We don't know if it's just somebody out there in the ether trying to cause issues. So I think if we're talking about parent involvement and parent appeals, we probably need to know it's a parent.
It's
Well,
just,
you've got bullying and intimidation in here. So there's an example where physical injury, psychological trauma, bully or intimidation, where, again, I do think my example was not a good one, but if you take it against that, you see bullying and intimidation, and I don't know. I just, again, if someone does it anonymously, they've got no fallback in any of this. But at the same time, we do have whistleblower. Um, a person could put a whistleblower complaint in through the ODE that would fall just by the nature of the complaint under this particular policy. So again, I think it's just a good door to keep open. That's all.
So I think were we looking at modifying this? Or are you leaving it as is, Mrs. Walsh?
Um, I'm trying to catch up here with the words. So John, your point is you think it's good to keep in there, but to change it to may or may not.
Yes, at the discretion of the district. Anonymous written concepts may or may not be investigated at the discretion of the district is what I would recommend.
No, I just want to take the whole language out. That's what my motion is. I'm going to keep it because may or may not is the discretion that things may not get investigated that a parent wants investigated. If the parent can file a written complaint with the school principal or assistant principal regarding a topic addressed in this policy. If it's how often is that going to happen? I wouldn't think it's going to happen very often, but if it has to do with bullying or something, it may be anonymous, and I think it should be if that's what they want. So I'm just going to leave my motion stand and let the chips fall where they may.
Mr. Krishna, were you going to make a motion? Oh, yep, you're right. You're correct. Sorry. Any other discussion on this motion?
I need just a few minutes. You guys, I mean, if you guys give me a minute. Thanks.
So the motion on the floor is to strike the final sentence out of the first paragraph, correct?
Correct.
Yeah, the first paragraph under concerns and appeals procedure.
Right. Thank you.
I'm ready. If you're okay, I'll restate the motion, Mr.
Yes, please.
President, and then I can do roll call.
Yes, please.
Okay. Mrs. Walsh's motion is as follows. Motion to remove the language under concerns and appeals procedures that reads, anonymous written concerns may not be investigated. And this is in policy IGBLA. I have her as the first and Mr. Kirshner the second. If it's okay, we'll move forward to roll call. Mr. Kirshner,
No.
Mr. Bauer,
No.
Miss Gray, Miss Walsh.
Aye.
Okay, motion fails.
I
Oh,
didn't-
I'm sorry.
it's okay. Ms. Dowdellberger, no.
Okay, motion fails.
And I'm ready to vote on the original motion from Ms. Gray or Mr. Kirshner. Are you going to make a motion for the may or may not language?
Yes, I would move that we change the language of the end of the first paragraph under concerns and appeals to anonymous written concerns may or may not be investigated based on their merit at the discretion of the district.
I will second. Any discussion?
I may just need him to repeat the whole thing. I got may or may not be investigated at the discretion of the.
Yeah,
The
it's in the
district-
closed captioning.
Well, I don't have that screen. I'm sorry.
Oh,
That's why I was just asking you to repeat
yeah.
that last part. May or may not be investigated regardless of merit. If I heard you correctly.
At the discretion, based on their merit at the discretion of the district, yes. May or may not be investigated based on on their merit
Mhm.
at the discretion of the district.
Thank you. And I have Mr. Bauer second. Thank you.
Any discussion on this motion?
And just my understanding is just as a question that in this case is just further clarifies either way saying may, but we just added may not, correct? May or may not, it's the same thing. Correct?
That's how I interpret it. That
Okay.
it's may or may not, and it's based on the
Yeah,
merit.
that is the language, may or may not, based on their merit at the discretion of the board. Yes. May or may not be investigated.
So you're saying it reads, anonymous written concerns may or may not be investigated based on their merit at the discretion of the district, correct?
Right.
Thank you.
And what do you mean? Is there something specific, example when you added in merit? What was your thought? Was that, someone of a certain, what was your thought?
Is there something specific?
When you added in that based on
Right.
their
So
merit,
if
I just wanted to,
obviously, I think it just gives clarity. So it's not willy nilly. It's saying that if we get a written complaint and it's anonymous, we're going to at least look at it to see if it has any merit. If the superintendent or whoever he assigns says, there's not enough information here, I can't, there's nothing I can do with this, then it's meritless and we feel no compulsion to move forward. If they look at it and say, hey, this looks like we've got something we really need to be concerned about, then they have the ability to move forward. I just thought it took out the ambiguity, like it was any favoritism or willy-nilly, I guess, for lack of a better way of saying it.
no, this isn't the loaded question. Yes. My question is, as we get to the bottom of this paragraph, it talks about the procedures. So then we would need to come back and discuss the procedures on how to, or what do we already have in place for this? I guess that's my question. I don't know if that's necessarily about the motion, but it is in the policy. The last paragraph discusses that, and then just wanted to see what the administration may have to say on that part. I just want to make sure it's clear and where I'm doing it, an open session.
Yeah, so it's implied, I believe, in all the language here, right? If you're anonymous, you obviously have no ability to appeal anything.
Oh no, my question was to the administration team, just
Oh, I'm
as
sorry.
far as with that language potentially being added, how is that going to work with the procedures to ensure prompt and fair attention to written concerns about this policy? Because that would be like the next step, right? If I'm reading that correctly. Okay. They shook their heads just so right now. I'm still
I would need some time to kind of think
right.
about,
Yeah.
kind of think about this. See, I know it's at odds with some negotiated contracts. I know that I was trying to look while we were talking reference to other policies about anonymous things. And then taking that line and applying it to the whole of this policy would take a little bit of a time for me to feel comfortable assessing that.
Thank you. That's what I wanted to just know, so we had that. And when you said that we're talking about like our union folks. Okay. Thank you.
I want to clarify what the superintendent said. You said what John's proposing is at odds with negotiated contracts. Is that correct?
Yes.
Which contracts and what part of this contract?
I mean, I think we've had pretty extensive discussion about anonymous complaints. That the procedure to evaluate that is in the teacher's contract. I don't know. I said I know for sure it's in GMLEA. I don't know what the language is in OPSI off the top of my head.
1 second.
This said that the computer translated that to what the language is and obesity off the top of my head. What the language is and what off the top of your head?
I think I was saying GMLEA contract that I know that's specifically in there in the complaint procedure, and I said I do not know the OPSI language off the top of my head.
Oh, okay, thank you. It's
And OPSI wouldn't be a word
it's
that I would
having,
know.
yeah, it's changing it.
It doesn't know how to
Thank
translate that.
Thank you.
And I'm only asking this just because we're in the public and just want to make sure we're discussing those things as we're considering the language change to vote on this evening. What does that look like? And there's another part of this policy that we have to enact. So I just wanted to make sure we were all kind of thinking about that and next steps forward.
All right. Any other discussion on this motion?
I had one. I had some community members point out one thing that, and I'll just throw this out for consideration. Obviously, if you have, if you were to take a complaint, or I'm trying to find the right word. Give me a second here. A protection order, right? So if you're an employee and anyone could file a protection order against you and that would cost you your job, then that could become leverage and all kinds of problematic, right? So we're not saying, our employees, if they have a protection order, can't work in the district. However, we're saying that parental involvement is not allowed if a protection or consent agreement, okay? But then if that is the measure, then shouldn't we be holding our employees on supplemental and voluntary contracts to that same level? In other words, if you're not going to let a parent be involved in coaching because they have a protection order, should we allow an employee to take a supplemental contract if they have a protection order? It seems to members of the public when they looked at this that it might be two-faced, if you will, for lack of better terms, right?
Where are you at?
Yeah, I'm
on
asking
here?
you.
Nothing in this policy or activity violation court include any of the following. A condition of bond, a protection order, a consent order, a condition of community control sanction.
Can you give me what paragraph? Like, are you under definitions, parent authorization, sexuality content, student health and well-being? What part of the policy? Are you at the very beginning?
Right.
Gotcha.
If I'm understanding this correctly, we're excluding parental involvement. Am I wrong? If you have, for instance, condition of bond, protection order, consent agreement, or community controlled sanctions, we're excluding community involvement for those type of issues. Am I misunderstanding that? Is that why that's not mentioned? Can you help with that, Mike?
Yeah.
So he's referring to the first page. It's in green. If you have a color copy, it starts with nothing in this policy. At the bottom of the first page, nothing in this policy requires disclosure or activity in violation of any court order, including any of the following. And the second one is a protection order or consent agreement pursuant to all those revised codes. So if I'm understanding correctly, your question is about, does this or does this not, this policy require disclosure or activity in violation of any court order? It can, in particular, protection order. I don't think it does. I think it's just the opposite. Nothing in this policy requires this disclosure or requires disclosure of activity in relation of any court order, including a protection order. So a parent, maybe if wanted to be very thorough, nothing in this policy requires a parent to disclose. I'm not sure about the or activity. I think that's thinks that there are some words omitted perhaps. But I believe that it's saying that the parent does not have to disclose a protection order.
Okay. Authorization. Give me
Is there a possibility that that or should be of? Nothing in this policy requires disclosure of activity in violation or an activity in violation. I'm not certain about why the word or would be important there.
And you're on the number 2, correct?
Well, I think the question really pertains to the wording that starts with nothing in this policy requires disclosure. So in essence, what it's saying is nothing in this policy requires a parent to disclose a condition of bond or a protection order or consent agreement. So I think the wording there is fine. I believe the problem lies in the word or. Nothing in this policy requires disclosure or activity in violation. There seems to be omitted words. Yeah, it could be, and that could be incorrect too. Nothing in this policy requires disclosure of an activity in violation of any court order. That seems to work. As in reconsidering it, it actually could work. It's because the sentence concludes or continues with that the word of is at the end of it. So nothing in this policy requires disclosure or activity in violation of any court order, including any of the following. So it could read, nothing in this policy requires disclosure of any of the following. I believe now that that could read as is, as originally stated. Nothing in this policy requires disclosure or activity in violation of any court order, including any of the following. So again, it could read, if you divide it up, the first part would be nothing in this policy requires disclosure of any of the following. Nothing in this policy requires activity in violation of any court order, including any of the following. So this is just protecting the parents, or saying that the parents don't have to disclose any of these things to actually have a concern or to be involved with a matter that they have a concern with.
It was the opposite of what how John was reading it.
Yes, nothing in this policy requires disclosure. So it's saying that nothing in this policy is saying that the parents have to disclose any of those things that are listed. It's a protection for the parents.
Yeah, and I think I was misreading this to believing that these were disqualifiers and the things under the green, right?
Yes.
The 1, 2, 3 items that aren't scratched out under nothing in this policy requires are not exclusions to the ability to be involved as a parent in coaching or anything else. Is that correct?
That's how I read it as well. Yes.
Okay, thank you. I
You're welcome.
just misinterpreted its purpose. Thank you.
You're welcome.
Let me know when you're ready.
I was just gonna say, we're a little over an hour in. This is a required policy. We're debating changing the sample language. We haven't really done any analysis on some of the proposed changes. Maybe we're not ready to vote on this tonight.
I think we only have the one thing left on our agenda to vote on, and that is whether we change it to may or may not based on that language. I don't think there's anything else, is there?
We have two motions still left. We have the language of may or may not, which is your motion, and we still need to vote on Mrs. Gray's motion of modifying the language that says the superintendent. Let me go down to it. Do you have it? Actually, do you mind rereading that one?
Yeah, just trying to catch my note.
Yep. Sorry. But to answer your question, Mr. Krishner, there are two agendas still that we need to vote on tonight for this policy.
One was, am I wrong that one was at the request of the superintendent to add or designee, or is that something different?
Yeah, that is the one. So the modification of the policy to change the word instead of it to say they to say superintendent, and then also add superintendent or designee.
Right.
So that is the first one.
Okay. Well, that one's, I would say, considering it came from the superintendent, completely non-controversial. It's just I think a typo, or yeah, it doesn't match, so that should be simple. Can we get down to it?
Yep. Any other discussion? So
Where are we at?
So Mrs. Dottoberger, can you reread
Yes, I can.
the motion that we are voting on right now?
Yes, sir. Yes,
Thank
Mr.
you.
President. So the motion that we have currently on the floor is as follows. Motion to modify the language that anonymous written. Go to the thing because I didn't type it all the way out verbatim. But anonymous written concerns may or may not be investigated based on their merit at the discretion of the district.
Right. And one last thing I promise. You keep in mind that as you're talking about how this conflicts with the possible OPERS or union contracts, it is quite possible that a written complaint could be about a parent coach or a parent problem or student problem. Is that not correct? In other words, it does a written complaint wouldn't necessarily have to be employee based, correct? In this scenario.
Yeah, correct. And actually, that was the other thing I was looking at. Our policy KLD, public complaints about district personnel, is another policy that has complaints about personnel are investigated fully and fairly. Before any such complaint is investigated, it must be submitted in writing and signed. Anonymous complaints are disregarded. So we do have that this would put us in conflict with some of our other policies as well.
Right, but what I'm saying is this keeps it, that is written, right? But this would keep the door open if the complaint was not employee related, correct?
Well, this says that would be complaints regarding a topic addressed in this policy. So it's directly related to this policy.
All right. Are we ready?
Let's do it. Yep. No.
Are we ready, Madam Vice President?
I mean, this policy is about the district obtaining parental authorization and being open, I guess, with the parent. So all this that John's wanting to add just directly relates to this policy.
Kathy, can you repeat what you just stated, please?
The changes that John wants to make directly relate to this policy. They don't relate to other policies. If you read the paragraph.
I was just going to say, in order to fully state um, that language, I would just want to make sure we cross-reference the other policies that are listed. And I think Mr. Morbitzer did share with us in the beginning that if we made changes, and I'm not sure if this changes that, an example of that, that it would require us to make the changes to the other policies. And as you notice on the last page, which lists the Ohio Revised Code sections, as well as the cross references for the same policies. I just want to say that for the record, but I don't know if that is what you meant, Mr. Morbitzer, when you shared that if we were to take it out or do something else, would it then impact those policies?
Yeah, it's best to advise for a board to keep its policies consistent among the policies. It's one of the easiest ways to lose a lawsuit when you have such inconsistency among your policies.
Thank you.
So if I'm hearing this correctly, then you're saying what we're having in here is what we should not be adding or modifying to this.
I was just saying I would like the opportunity. Ms. Walsh made the statement that John's changes do not impact other policies, just this policy. However, this policy cross references IGAE, IGAH, IGAI, IGBL, JHC, JHCA, JFH.
And how do they affect those
I,
policies?
Ms. Walsh, I was just saying it cross references, and for to say it does not impact, with those being cross referenced, I would just want to check and not say that as a blanket that it does not impact, because I don't know. I was just making a statement and I was just saying it out loud. We're just having discussion. That's all.
So, as
Yeah, and I'm trying to contribute to the discussion. I'm asking you, how how does that impact those policies?
I was just saying, as I mentioned, we would need to double check to ensure it does not, if we make that change. That's what I was saying. And that's why I asked Mr. Morbitzer when he first got up earlier. I don't know if you were about an hour ago, he shared that making changes to this policy, some of the language in it could impact our other policies. And then he just stated with the inconsistencies could then make us liable for a lawsuit. And I know you're contributing. I wasn't saying that it does or does not. I just said I would want to at least cross reference and double check these since they are listed on this policy. There's several other policies cross referenced here. So I would just want to make sure crosswalk it basically, that if we make this change that it's in compliance with these other ones that we already have. That's all. Based off of this recommendation.
yeah, I think that's an excellent point. I think the deeper issue is there's a whole lot of state law that allows for anonymous complaints. So it's quite possible that we have a whole bunch of policies that could really get us in trouble because, obviously we've got reportable offenses that someone is definitely allowed to report anonymously. And then if we have written in policy or written in just because it's written in a teacher's contract or one other contract doesn't mean that it's fully vetted legally, and even though it might be in 90% of the contracts across the state, doesn't mean it's been fully vetted legally. So I think there are deeper issues with that. So anyway, I understand what you're saying. I just think we need to understand that, and we also need to understand the whole depth of our responsibility to respond to complaints, whether they're anonymous or not.
When you're ready, on to roll call, please.
I want to make one other remark. If our main
Can you wait 1
responsibility,
second, Miss Walsh? I'm trying to get caught up on these and then.
all right,
Thank you, ma'am. Ready, Miss Walsh?
yeah, I was just going to say that our main responsibility is to keep our students safe, and our parents need to be informed. And I would hate for someone not to make a complaint because they're afraid of retaliation against their student. And by having anonymous in there in some form or another, that we are promoting the safety of our students.
All right, I'm ready. Mr. President, if we can move, if it's okay, move forward with roll call and I
Yes,
can
please.
restate the motion. So
Yep.
we're clear on what we're voting on.
Yep.
Mr. Kirschner made the motion to modify the language that states anonymous written. Let me go back to my little, I miss that word every time I do this. I'm so sorry. Anonymous written concerns, excuse me, may or may not be investigated based on their merit at the discretion of the district. It was seconded by Mr. Bauer. Roll call is as follows. Mr. Kirschner,
Aye.
Mr. Bauer,
No.
Ms. Gray,
No,
Ms. Walsh,
Aye.
Ms. Aldoberger. No, and I want to state why I'm voting no, as the other language still protects with the word may. Thank you.
I would like to make a comment as to why I'm voting no is because I want us to stay consistent in our policies, and our policies are stated the way the policy originally reads, which is anonymous written concerns may not be investigated, and that is consistent with all of our policies.
I'm in the same boat. On to Mrs. Gray's motion. Mrs. Dalderberger, do you mind rereading
Yes,
that motion?
yes, I can, Mr. President. 1 second. All right, the motion from Ms. Gray is as follows. We made the modification to the policy to change the word they based on the recommendation from Mr. Morpitzer to superintendent, so we can identify the actual title, and to add superintendent or designee, as the designee could be someone else other than him that gives that opportunity for that. It was seconded by Mr. Bauer, and roll calls as follows. Mr. Kirschner,
Um, I would like to have a discussion. I mean, I'm not following what you're saying here because you didn't say what page number, which paragraph, which topic, which sentence.
oh,
If you could do that, please, I'd appreciate
are-
it. Thank
we
you.
didn't do that for the other, but I will gladly do that. 1 second, ma'am.
This motion is simply to add the or designee language, correct?
And superintendent, so she wanted me to be specific on the actual location, so I'll do so at this time. Under the concerns and appeals procedure, second paragraph, first sentence, add the word after superintendent, add or designee. Everybody there? Okay. In the very last sentence, remove the word they and add the superintendent determines the resolution to the parent's concern.
Thank you.
Any other discussion?
Yeah, I have one. And I'm not trying to drag this out. I'm just trying to cover it correctly. Section 3313.6610 outlines the law regarding our anonymous reporting programs. Given that we have specific requirements as being part of the Safe Ohio tip line operations, I would ask that the board president submit the relevant policies that state that we may not use anonymous complaints against 3313.6610 and advise the board.
All right. Can you restate that for me, please, Mr. Kirschner?
Yes, actually, if you all could, if it's not a problem, if you can click on the CC at the bottom of your screen, exactly what I said will pop right up in front of you.
We don't have that screen, so
Okay,
yes,
sorry.
sir. Unfortunately, So if you could just slow down just a little bit and then
Yep, here we
restate that,
go.
and I
Let me
can
find it.
capture that, please. Thank you.
Okay. As being part of the of the Safe Ohio tip line operations, I would ask the board president to submit the relevant policies that state that we may not use anonymous complaints in our investigations of employees against the Ohio Revised Code.
Once can you go back? You said submit the relevant policies that stated we cannot. And is this a motion or is just a
Yes.
statement?
Yes, no, I'm
Oh.
making a motion
Okay.
that
One moment, can I hold you up? Can we vote on the motion that got chant
Yes,
first?
please.
Can we
I-
vote on the
All right.
present
Yeah,
motion first?
So
I thought it was a statement at first, so that's why I was
All right.
capturing it.
can we let's go back to the original motion, Mrs. Gray's motion,
Yep.
and then after that we can
Okay.
go to Mr. Kirshner.
Yep. Perfect.
All right.
I thought we just voted it on that. I'm sorry.
No, we were
We did.
voting on it, and then we thought you just had another comment, but it turned into a motion, so that's kind of where we
Thank
got
you.
a little. Yep, no problem. So Ms. Libby Gray's motion is as follows: that under the Concerns and Appeals Procedure section, paragraph 2, first sentence, it adds the words "or designee," so it'll say principal's decision to the superintendent or designee. And then the last sentence changed from the word "they" to "superintendent." And I have Mr. Bauer as a second, and I'm ready for roll call now.
Yes. Please.
Mr. Kirshner,
Aye.
Mr. Bauer,
Aye.
Miss Gray,
Aye.
Miss Walsh,
Aye.
and Latoya Dowdell-Worker, aye.
Motion passes. Now to Mr. Kirshner's motion. Please restate your motion, Mr. Kirshner, and we'll need a second.
State it slowly, and hopefully we can get
All
it.
right, give me one moment because I need
All
to
right.
now.
So, given that the Ohio Revised Code 3313.6610 outlines our responsibilities for anonymous reporting programs, I would like to request that the board president submit our policies that state anonymous complaints shall not be investigated to the prosecutor's office for clarification against 3313.6610.
Submit the policies that state anonymous complaints shall not be investigated to the Franklin County prosecutor. Is that correct?
Correct.
I'll second that.
I have Mr. Kirshner as first, Mrs. Walsh as second. On to discussion, please.
It's relevant to the discussion we've had today, and it's important that we follow um, the laws of the state of Ohio. So we've sworn oath to do so. So asking the Attorney General would be in the best interest of the board.
Ms. Walsh, you were very low. I'm so sorry. I could not hear anything you stated. If you could repeat that and lean in the mic just a little bit more for me, please.
I'm sorry. I have to get the closed caption back up. One moment, please. I said, um, that motion is relevant to the discussion that we've had today, and it's important that we follow the laws of the state of Ohio. We've sworn to do so. Um, so asking the Attorney General would be in the best interest of the board, or an opinion would be in the best interest of the board.
Any other discussion? Hearing none, when you are ready, roll call.
I would just, only thing I would like to say was just that that our policies, go through our policy provider, which is through the legal side for OSBA. So yes, they have been vetted at least by a series of lawyers. I would hate to think that we are intentionally violating this. And I would recommend, or at least in addition to, this is what we are going to vote on and do, we would also bring this attention to our policy provider if there are concerns.
Sure, absolutely. I mean, there's no harm in submitting it. I'm assuming that this is a free service that's provided. Is that correct, Mr. Kirshner?
Right. The prosecutor's office is our de facto legal service, and they do not charge us.
All right. When you are ready, roll call, please. Mr. Morviser, did you have something you'd like to share?
Yes, thank you. I want to point out to the board that the policy that we're considering is specific to Ohio Revised Code 3313.473 parental involvement policy, meaning that we have to have a policy. And I want to point out the nature.
3313 what? I'm sorry.
It's 3313 point 473 parental involvement policy. And I want to point out the nature of this particular promoting parental involvement policy. This is largely about, the impetus for this is what appears on page 3, I believe. And this is covered under student health and well-being. The nature of this is district personnel are prohibited from directly or indirectly encouraging a student to withhold information about a parent concerning the student's mental, emotional, physical health or well-being, or a change in related services or monitoring. District personnel are prohibited from discouraging or prohibiting parental notification of and involvement in decisions affecting a student's mental, emotional, physical health or well-being. We're kind of looking at this, I think we've been looking at this as general complaints. This is not general complaints. I was just pointing out that we want to be consistent with our policies. What Mr. Kirshner was pointing out is policy, and I'll repeat what he pointed out, Ohio Revised Code 3313.6610, anonymous reporting programs. That specific Ohio Revised Code pertains to the fact that we have to register with Safer Ohio tip line, and there are several provisions under it, and there's even information that we have to collect based on those anonymous calls. That is the avenue that the state has set up for anonymous reporting, having to do with disciplinary actions taken the previous school year, the number and type of mental wellness referrals as a result of anonymous reports, the race and gender of the students subject to the disciplinary action mental wellness referrals, and the race and gender, any other information the Department of Education or Department of Public Safety determines necessary. The nature of that was to allow for an avenue for anonymous reporting. So that exists regardless of whatever change you want to make to this particular policy that we're looking at, promoting parental involvement, which actually is about something very different in its nature. So again, since the state has allowed for, actually not allowed for, has required both policies and especially an anonymous reporting program, that will remain there regardless of whatever you put on this page about anonymity. So parents have the ability, or anyone has the ability to, on that State for Ohio tip line, make their anonymous reports.
Right. So the question that I have, and I think maybe they would answer this is saying, you know, you have an anonymous report. We have we have a responsibility, not just under this, but of all these policies to report back to them. Now, so if I see something in writing that says, hey, we don't have to do anything because it's anonymous, I'm not very clear on how we report back um, on this issue. I'm also not very clear on the fact that they can give their name and still remain anonymous to us. And then we have all these policies that say, hey, if it's anonymous, you can't do anything. You can't take formal actions, et cetera, et cetera. So beyond just this one page, as you say, it's important to align all our policies. I'm concerned that there might be a misalignment, policy versus law.
That's a fair concern. And what I'm always encouraging a board to do is have consistent policies, and this being one of them, consistency across the board that you do or do not accept written, anonymous written communication or complaints or whatever, or concerns. But it's very important to point out that there already exists an anonymous reporting system that we are beholden to, and that we have to report that. So that's the way that we report anonymous complaints. To make another way to report anonymous complaints doesn't seem necessary.
Right. And I wasn't, okay. I guess I see what you're talking about, but if an anonymous complaint comes in, I guess you're saying that if it comes in, it's not going to fall under this particularly policy, but then again, it sure wouldn't hurt for me to know that.
No, I encourage what you're saying. I encourage alignment and checking and double checking policy with whatever authority you'd like.
Thank you.
Any other discussion? On to roll call, please.
Mr. Kirshner,
Aye.
Mr. Ballard,
Aye.
Miss Gray,
No.
Miss Walsh,
Aye.
sorry, I'm messing up something. And Miss Dowdleberger, no.
Motion passes. On to the original motion. Or, I'm sorry. On to we have to approve the full policy. Yes, we have to approve the full.
Oh, I thought that was, because I
I thought
amended
it was,
it.
he should amend
I
it.
originally amended
Oh.
my motion to.
Sorry.
It's done.
Correct.
Yes.
That-
We're good.
We're good on
Plenty
that
of-
one. Thank
Plenty
you.
of modifications.
Thank you.
All right, on to the cell phone policy.
She, to modify the approval of the policy with those two updates. That's what the motion was.
All right, cell phone policy.
Okay. The cell phone policy, we provided the policy from Dayton Public Schools, which was a topic at the last meeting. The Ohio Cell Phones in Schools Model Policy, which was discussed at the last meeting. And then the OSBA policy. So what I would like to do, I don't know if we need a motion first, but I would like to have Mike do an analysis of the three policies. What's different, what's alike, what might be of interest, and then well, not more importantly, but additionally important, I wanted to have Mr. Smathers give an overview of his work with the administrators and safety committee as to the action steps about how the cell phone policy, whatever it is, would be rolled out and implemented. So do we need a motion first?
Yes, sir.
So moved.
Second.
Hang on one second.
So Ms. Gray is first, Mr. Kirschner second.
Yep.
To move
On
forward
to
with the,
discussion.
all right, thank you.
So Mr. Morpser, will you take us through an analysis of the three policies?
Can I make a comment first? The Dayton policy brought forward is totally irrelevant. It's dated 2020. They've made all kinds of changes. They didn't do a good job of making the changes in their board policy. They made their changes through their student handbook, etc. So what we're looking at here, as by way of policy, is pretty well useless because it doesn't reflect at all what they're doing. So I don't know that we need to spend much time on that. I also wondered about incorporating the policy that Libby sent forward, if that's a possibility. Was that your desire?
That was from the state. That wasn't, I didn't
Okay.
create that. That was,
And we have that
sample.
captured. I hope you all will bear with me. I'm not very well prepared, as you can imagine. This is embarrassing, and I just as you know why I'm not prepared.
I'd like to make a motion for a 5-minute recess, please.
I second.
All right, roll call. Mr. Kirschner. He said aye. Latoya Dowdell-Berger, aye. Mr. Bauer.
Aye.
Ms. Gray.
Aye.
Ms. Walsh.
Aye.
It's 8:40. We are at recess. It is 8:47 p.m. We have returned from recess, and to note, Mr. Kirshner left the meeting. All right, on to cell phone policy.
All right, Mr. Officer, can you give us the quick overview?
Yes. So I'm going to discuss 4 different documents instead of 3. And I'm also going to include in that Dayton Public Schools because I did find some usefulness in that particular policy, even though it is dated June 16, 2020, a long time before the state actually enacted their cell phone Ohio Revised Code. So I am going to refer to Ohio Revised Code first. That's Ohio Revised Code Section 3313.753, Prohibition Against Students Carrying Electronic Communications Devices. What's especially good about ORC in this matter is that the definitions are offered. Definitions for electronic communications device, school building, school grounds, or premises. Those are all defined in Ohio Revised Code in section 3313.753. I'm going to recommend that we take that in an advisement, that section for definitions. And I'm going to include an additional definition to differentiate between electronic communication device and personal electronic device. So again, that's Ohio Revised Code 3313.753. That's where all this started.
Do you have a printout of that policy?
I do not have an additional one. I have one copy. It's Ohio Revised Code section 3313.753, Prohibition Against Students Carrying Electronic Communications Devices. So, of course, that Ohio Revised Code led the Ohio Department of Education to put out guidance. That guidance is entitled Ohio's Cell Phones in Schools Model Policy. I believe that you're aware of that one. You've had that in your possession before. Again, that's Ohio's Cell Phones in Schools Model Policy by the Ohio Department of Education and Workforce. The interesting thing or the notable thing about this policy or model policy is that it focuses only on cell phones. I don't believe that that's the board's intent, and I don't believe that that's in line with Deputy Superintendent Smathers' recommendations from the committee that he's been working with. So I'm going to talk about that in a moment as well. The Dayton Public Schools policy that Mr. Kirshner talked about, I did find some usefulness in that policy. The policy is thorough, but is bordering on too much information that needlessly strays into other policies that they have. You don't need to outline every single, you make that reference at the end of your policies to a particular or set of particular board policies that are included or are related to this, but you should not put all the information that Dayton Public Schools necessarily put in there. So we'll talk about that as well. Now, what we've been looking at, I think what the board has been considering is, I think it's titled Copy of Use of Electronic Communications Equipment by Students. As I said before, it does not include personal electronic devices. We necessarily have to include personal electronic devices because personal electronic devices don't necessarily have communication powers or communication capability. So we have to focus on both electronic communications equipment by students and also those that may not, which includes many PEDs. What Dayton Public Schools also does is it offers a list of personal electronic devices. Problem with that list is that includes some things that are going to that are either outdated right now, like pocket PCs, or it includes some things that may soon be outdated, or some promoting of particular brands of devices, for example, iPhones or iPads or Apple Watches. What we should do is not promote individual brands in our policy, but what they are in general. So overall, I believe that what we should be considering is something that probably cannot be decided tonight. We should probably involve all of these recommendations, these guidelines, Ohio Revised Code in consideration, because what we're putting out so far, or what we're considering for our policy, really needs more information. Not a lot of information, but also what it needs to do is continue to focus on, we're talking about what Mr. Smathers is going to explain to us. We're talking about a time period beginning with when students arrive at school to when they leave school. that's going to be all encompassing. That's not what this particular policy says that we've been considering, because it says recognizing the impact of student cell phone use on student mental health and achievement and the distractions cell phones present within the classroom. This basically focuses on the classroom throughout, and our policy should be reflective of what Mr. Smathers is going to present, which is the time period from when the student arrives to when the student leaves the school premises.
Any discussion about what Mr. Morwitzer just presented? Okay, I thought that was well done. Thank you, Mr. Morwitzer. I do want to say that this isn't something new, and we've been working on this for quite a bit, including 2 of our board members who's part of our district safety committee. I also want to add that as of last month, parent advisory committee, that we're including the parent advisory committee also in some of these discussions. We need a solid foundation of a board policy to start with what our practices, procedures, and guidelines are on what we're going to do to follow through with our policy, our board policy for cell phone and personal devices. The elementary schools have done a really good job of keeping the cell phones off and out of sight in their backpacks and not a disruption at school. In fact, and I'm looking at Miss Gray, we were part of some of the discussions with the elementary students in the student advisory, and the students even say that the cell phones and personal devices have become a distraction and they want those out. It's amazing that the kids are on board with this. So with those committees, talking to teachers, staff members, bus drivers, transportation, um, the district safety committee, parent advisory, and student advisory committee, that we came up with a guideline of what we're doing, but we're still talking about this. Wednesday, we have our district safety committee meeting, and again, we're going to continue this conversation. The conversation has led to this point, but we still need a policy for a foundation of this, and that is that from the start of school until school is finished, that the cell phones are to be off and out of sight and not a distraction. I want to say that this approach is very positive, that we're trying to help with the mental health of our students, the student interactions and development of how to interact with each other, to lessen the amount of bullying, harassment, and intimidation that has happened as a result of these personal devices and cell phones. Um, we're also asking for no headphones, uh, no watches, no tablets, and personal laptops. Anything that would uh, require them to get on their own devices and get on social media and other things. Every student in our district is given a Chromebook and have access to everything that they need electronically to thrive and be successful in our classrooms and in our schools. So the only issue that we haven't settled on is what are we going to do with the students on the school buses? And over 80% of our kids ride school buses. And talking with transportation, that transportation has a rule that the kids aren't supposed to have their cell phones on at the buses, but we know that that has happened. And so that's going to be discussed at the next district safety committee meeting about the transportation and what that looks like on the school bus. The feedback that we've gotten from our parents is mostly, I want my kid to have their cell phone in case an emergency happens, or if I ever need to get a hold of them, or God forbid something happens in one of the schools. And we understand that, and we're taking that into consideration. So typically, a kid is going to come to school, they will have their cell phone on them or in their backpacks, but it is to be turned off and silenced and not to be a part of school. We're not, we're looking at those cell phones are put away and they're not coming out until school's over. That includes lunchtime, passing time, going to the bathroom, hallways, any of that. It's off. That's where we are right now.
So,
Now, I do want to say this. Our processes and procedures need to be separate from the policy. And mainly because this is something new and we're trying to figure this out, we may have to make some adjustments on what we're doing with our practices, procedures, uh, and how our corrective action. This is going to be new, and we'll have to make some adjustments.
So the policy that we're voting on is one that was already, it looks like from based off of our policies, what we voted on it in November 6th of 2024. So this
Right.
policy is already in place,
Right.
and does it comply with the deadline of July 1st?
Yes.
What was required in that policy?
Yes. I do want to mention, and Ms. Gray, you've been a part of this, the template from the Ohio Department of Education.
Mhm.
We were looking at that and following that template in what our practices will be.
So the procedures will be based off of that.
Right, especially the corrective action. But I don't want this to sound like it's a punishment. We're just trying to help our kids set clear boundaries with these cell phones.
Mhm.
And we're not going to let the screen time and these cell phones run their lives anymore. They're going to come to school and do what school is for.
So basically, right now, we are in compliance with Ohio Revised Code with our current policy that we have.
With the current policy that we have, yes.
Okay, so one of my concerns, I have like a list of concerns.
Okay.
My concern was if we implement anything, like the Dayton or, the school's model policy, that we wouldn't be able to implement and get everything in place for the beginning of the school year. So that was one of my concerns.
You want me to say something to that?
Yes. If you
What Mr. Morbitzer is proposing policy wise and is an enhancement to our current policy. But our current policy does meet the governor's expectations.
Okay.
Real quick, Mr. Morbitzer, I believe, did share the document with us that he's working on. Is that correct? Okay. Yeah.
Okay.
What? Are we going too fast?
Yeah.
Okay.
Sorry. Let me know when you're ready.
Well, I'm still where Paul said that we were looking at something you said, and then
Wait,
Libby jumped
We're
in and
not.
said,
The board is looking at.
well, no, you were saying something about looking at the expanding.
It's an enhancement. I believe
Enhancement.
Mr. Morbitzer is proposing or giving something to the board of an enhancement of our current policy. But our current policy meets the governor's expectations.
Well, if the current policy meets,
Hold on one second, Miss Walsh. I had Mr. Bauer and Miss Gray, and then I can go to you if that's okay. I appreciate it. Thank you. All right, and Miss Gray, you said something after he mentioned the enhancement piece of the suggestion that'll come to us from the board, which we and Seth mentioned that that we already have a copy in our email of the suggested enhancement from Mr. Morbitzer.
Yes.
Okay, what else? Did you
And
say anything else?
I
Okay.
talked about the Ohio cell phone in school model policy, and that my concern was if we implemented.
Oh, I had that
Oh, you
part.
got that.
Yep.
Then I haven't gone any farther.
Cool. Yep. All right. Then Miss Walsh, I'm ready for you. Sorry about that, ma'am.
Well, I'm sorry. Miss Gray said she had a list of questions though. We only got through one.
Okay.
Is that correct?
Yes.
1 second.
And while we got a second, I do want to say our current board policy at a minimal meets the expectations. Mr. Morbitzer is going to take it a step further.
Right. But currently, July 1st we are in compliance
Right.
as tonight.
Minimally.
Okay.
Okay.
We are.
Okay.
All right, Miss Gray, are you going to
Yeah.
enlist any more? Okay.
Okay, the other concern was, on our policies is to make sure that we take into consideration extracurricular activities and how students handle their cell phones at that point. Currently, from my understanding, you know, we don't have access for our athletes or our theater or whatever students to be able to contact their parents to come pick them up if they did not have a cell phone. So
So-
that was one of the concerns that I had of if us implementing any type of policy that was related.
I was bringing
to
that up with the district safety committee. Mr. Snyder brought that to my attention and asked about study tables after school and after school activities. I think that's something that we're gonna have to talk about. The idea behind everything that I said, as far as our practice, was from the start of school till the end of school. But now we gotta start thinking about the bus rides
Mhm.
and extracurricular activities.
I'll stop. Okay. The third item that I was concerned with was elementary students. Um, I don't see that there's a need for cell phones in elementary school, and my personal opinion is that we should not have them, and especially after meeting with all the elementary students that had gone back to their fellow students and asked them their thoughts. They all agreed that there was one student out of the 24 that said, no, you can't take my cell phone. But everybody else in that group was saying, I've talked to my friends and there is no reason. And they said that's the biggest part of what is causing the bullying and the distraction in class. They're watching videos on their phones, things like that. So,
So currently with our
sorry. You don't have to type mine word for word, just a blurb. He's all.
these are good ones, Libby.
Been thinking about this for a few weeks.
Yeah.
No, I can wait. I'll wait.
Okay, if I can say something right here, I just want to, for the record, with me being the treasurer pro tem, I'm trying to still insert comments because I have a lot of questions and concerns. So I do not want the general public to think that I'm not engaged, but I am trying to make sure our meeting minutes are appropriate for record so that when you see them, you can see what's discussed. But I do have some concerns, but I'm not speaking as much because I'm trying to capture. I just wanted to mention that for the record. I'm ready for whoever's next. Sorry.
Well, I'm just gonna reply. Right now, with the elementaries, the kids are not to have their cell phones. If they have a cell phone, it's to be put in their backpack. Their backpacks hang on the hooks wherever they keep their coats. They're not supposed to have them in their classroom or at school at all. Are there times where kids sneak and get their cell phones or don't put it up like they ask, and there are issues with that? That would come with the corrective action. Are you saying they can't have their phones at all? Right.
That's how I feel. I just don't think that there's a need to have it in the classroom. Um, the students, what they have told me during our meetings is that during free time they get to get their phones out, and that causes issues because
Right.
then they're on their games or they're watching videos or they're texting and bullying people at that point.
Right, and that comes with a fair and consistency across the district. Um, I will say that I did hear the kids say that. I heard what you're saying.
Mm-hmm.
The pushback from another point of view for us that we took into consideration were that the parents were given the cell phones to the kids and they wanted them to have them when they walk to school or walk home. So they wanted it for safety
Mm-hmm.
and communication. And I guess that's something we're probably going to have to talk about. I'll put that on the agenda for Wednesday.
Okay.
And if I could say the same thing as children that walk from the bus stop, there has been incidents in our neighborhood, even though the bus stop is not that far. They did have a watch for that reason because there were issues, and then there were times that if we were running a little late, they may walk from home and go in the house. So, yeah, or if their older brother wasn't at the bus stop, it was a way for them to reach out for help if there's an issue. So,
Oh.
that's my concern.
Good
All
point.
right.
And we had a pedophile in our neighborhood at one point.
Right.
That's
But
a
I
good
did
point.
hear what you were saying. I'm giving you the other point of view.
I
And-
appreciate that.
Yeah.
So I guess I'm going to interject then too. That was my other concern is I am all on board with no cell phones during school hours, but I do know like before school and after school, there's kids that might need cell phones from a safety perspective. So whether they're getting on the bus or they're walking home from school after school, some of our kids have a pretty long walk, and like what Mrs. Dottelberger had said, I mean, some neighborhoods there's pedophiles out there. There's people that are out there doing nefarious things, and so I would certainly not want to. I would want to prohibit any child from having a cell phone, but I do agree during school hours they need to be
Yeah.
off.
Absolutely. That's
Yeah.
And I understand your concerns, and that's a valid concern.
And if we have a teacher allowing their kids to use it during recess and the school says no, then we have to follow up with that.
The other thing was a tiered approach for the discipline.
Mhm.
I think is important. And then the last thing is when I first got on board, we had a policy of no cell phone use, and then it made the burden onto the teachers to be the ones to administer that policy, and it disrupted the classes. And they spent more time dealing with cell phone issues than they did in teaching. And so all of this is all well and good, but we've got to have something that doesn't put that so much of a burden on the teachers because they need to be teaching the students and not spending time being an administrator.
Right.
So,
Being consistent and fair about all of this along the way. I will say I'm proud of where we are with the elementaries. We can get better. I'm proud of what the middle schools have done to this point, and we can get better. The high school is going to be our biggest chore, and we're going to have to give Mr. Altman and that staff over there some help.
Yeah.
And I want to be clear. I know we talked about corrective action, and there's going to be tiered approach about helping kids make good choices and good decisions about this, but it's a positive approach, and I want to take it from a viewpoint as a dad. For the kids' sake, we got to help them break away from these screens. We got to help them see that there's a whole life beyond these telephones and these cell phones, and there's kids your own age right across from you that are ready to talk to you and ready to interact with you. And I think our kids are losing some of that development and that interactive with their own peers, just sitting down and talking with kids at lunch and interacting with kids in your classrooms or during class change, and not have your face in the screen, on top of protecting kids from the things that are happening on social media that's hurting kids with bullying, harassment, and intimidation.
Mhm.
Mrs. Walsh, I believe you were next.
Thank you. First, I sent everybody a policy from Akron City Schools, which I thought was good. So I hope Mike reads that one when he's working on this. We also received a email letter from a parent, and the video on that was very good. Mike, did you get a copy of that?
Yes.
Okay, good. I was going to send it to you if you didn't. Did you, Paul?
Yep.
Yeah. Okay. I thought it was very good and had a lot of great information. Definitely do not think we should allow cell phones in the schools. Well, I know we have to lock them down or something. Kids are going to bring the phones. The policy should include what, in my opinion, should include what the discipline procedure will be. I know that's part of the procedure, but I think that should be in the policy, and I think the parent should have to come in and retrieve the cell phone. I don't think it should be given back to the student. Um, I don't think it needs to be a 3 strikes you're out. This isn't a baseball game. This is serious, and I think it needs to be a policy that's very firm right up from the get-go. You're going to lose your right to have the cell phone at the school if you bring it and get caught with it. Um, there's a lot about the backpacks, having them keep them in their backpacks. That's not successful because they go in the bathrooms. So I think we should have a report from the treasurer on the viability and what the budget would be for pouches or cell phone lockups or whatever, looking into that, decide would be a good option. Uh, those are just a
We've
few of the
discussed
things.
all of those, and we're looking at other schools that have tried different versions of that. So, everything that you just said, we're taking into consideration.
If I could say that I know when we start looking at and I'm trying to keep up, but I just don't want to miss my thought, and then I may have to go back and have to repeat something. But that we should be mindful of also our parents, because there may be parents that are working multiple jobs, and I know we want them to come pick them up. So I don't know if we'd be able to be flexible to have additional hours in those instances, because if you're the parent that's you are involved, you're doing the right thing, but maybe your student is not necessarily doing the right thing. You can't take off work. If you take off work, you could be in jeopardy of losing your job. You want to just be mindful of everyone's situation. So I don't know if there would be provisions for things like that, because not all parents can take off work, or not all parents, are able to meet those hours. So I just wanted to yield that thought, not saying they shouldn't pick it up, just saying if we could be mindful, is there a way when we're thinking about the procedures and implementation to provide maybe not a 6 to 2 time frame, especially for the high school, those kind of things.
Right. And I'll just mention, as we were talking about our corrective action and when we would take the phone and have a parent come pick it up, and the kid relies on the cell phone to get home, and that was brought up too. It's like, do I take the kid's safety piece as they walk home because they didn't do what they were told at school? And so we had some discussion around that. I do want to say again that I know Kathy mentioned this, and I get where she's coming from on this, but for our own practicality, if you could keep what we're doing about the policy separate from what the policy is, because again, this is going to be new, and our tiered steps, we might need to change it, but if it's in our policy, we have to come back to the board and do a couple reads, and I'd be glad to share with the board all along the way what our administrative guidelines are and what we're doing in as a reply as in reaction to our board policy.
So, oh, go ahead.
No, I strongly disagree with that. Other districts across the state are having it in their policy what the disciplinary procedures look like. I don't see why our district would be any district different. And from what I've read, which I'll try to get copies of that for everybody, the stuff that I have read, it says it's important to have those things in the policy up front.
So I'd like to know, timeline wise, are we going to be ready with your recommendations by the start of the school year?
I'm hoping, because I've been meeting with the principals, we're going to keep meeting to talk about what this is and what it looks like. But we'll have this meeting with the district safety committee on Wednesday, and hopefully it's definitely happening at the next parent advisory committee, and then hopefully we can come with what we're doing about it. But Mike's proposing that we at least come back and talk about the cell phone policy of one more board meeting.
I would think maybe June. Is that going to be too early? Or I'm sorry, July. It's been a day. By July's board meeting, do you think you'll be ready so that we could then review it and have it ready for August.
To be honest with you, I think if we could hit the ground running and start clearly communicating with our community, our parents, our staff, everybody, what we're doing and what it looks like. Our principals are planning on doing video recordings. They want to send text messages, emails. We're going to have it posted on the website, what we're doing. But we got to get a solid foundation of what the policy is so we can take some steps. We have a pretty good idea of what the policy is going to be. And I think we're on the right track, but we need a policy first.
So basically, we won't have a policy, and we're going to use this policy for right now, our existing policy, because it meets the state
Right.
guidelines. But then we're going to be having a new policy for the new school year.
Right. And we're using that model from the State Department that you have mentioned as a template.
And just so I'm hearing correctly, we're looking at probably 2 reads.
1 second. Can we, y'all want me really quick if you don't mind. So I have Mr. Smathers. We'll start back with, you asked the timeline. Mr. Smathers, you mentioned, and I don't have that, but then Mr. Bauer asked about, would we be ready by July's board meeting? Then Mr. Smathers then stated that, there's a comms plan, website, emails, all of that, but we need a solid foundation on the policy first. Libby then stated, basically, we're going to use our current policy and then have a new policy for next year. Am I missing anything? I just felt like, okay, because some of my sentences are not complete. I just missed that piece, though, between.
I think you just wrapped it up. I just want to be clear, though. We have a pretty good understanding of what this is. I just don't think we can start communicating until we have the policy.
I agree. I just want to make sure that we're not running out of time before the start of the
Right.
school
We
year.
won't run out of time.
Well,
because we're going to need 2 readings, which would mean 2 board meetings.
Yeah.
To adopt.
So what I was going to say is we didn't know exactly how this conversation would go tonight. The document that Mike shared with the group, there is another version of a policy that is a combined policy, put things together. I would like us to read through that tonight as a first read, so we would be potentially ready to act at our July meeting, because I agree with you. If it's at the end of July and we're just starting to put communications out, I think that's a problem. I think if we go over it tonight, if we have our second read and approve it, or approve a version July 8th, that's about halfway through the summer. That still gives us time to communicate, but I'm not sure I would want to wait and get only to a first read July 8th and then try to figure out when we can have another special meeting to get to it, because we have to get things printed, we have to get things prepared. So, I mean, we have some time, but I don't think we can sit and wait.
So
I don't have this policy.
Yeah,
He's getting
emailed
it for you.
Well,
He's gonna hand
need
it
to
to you.
have 48 hours
Well-
is what our policy is. for
well, we're
reading this
discussing
document.
policies, and that's what.
Yeah.
So
And our
this would
policy
be our first
says we
read.
need 48 hours for anything to be looked at so that we can properly prepare.
But this is the first read. It's not, we're voting on it.
So it's the first read, but we're supposed to have 48 hours of the
Oh,
notice
jeez.
of it 48 hours in advance of the first read. That's what our policy says.
Well, Kathy, we didn't have 48 hours notice of all the changes on the first policy that we read tonight. Those required policy.
Yeah, this is.
Those were all discussion that happened during the meeting tonight.
So could
Our
we
current
have-
policy meets state expectations. We can go by that.
But the new policy we need to have before school starts and be able to get the word out to the parents in a timely manner. We have to have the second read.
Correct.
Yeah,
Yeah.
we'll
We
vote
need to
on
have 2 readings of it.
All right, can we just pause for a second? I mean, is there a way I could ask for a 10-minute recess to get caught up? Because there was a lot that went back and forth. So if we could just do that, that way we're on recess and no one else needs to talk. So I would like to make a motion for a 10-minute recess. Do I have a second?
I second.
All right.
And at that time, can we, everybody read the policy?
Also, that would be a change in our special meeting notice.
Sure, it
if
is.
we're
One second.
Still on
first read. Does that say that in our?
We are
board
still on
agenda?
a cell phone policy.
Okay.
That
You're
is the
saying to have
topic.
the first read.
No,
Okay. and we're not gonna have a first read. That's great.
All right.
Thank you.
So on to
Roll
we have
call.
a roll call for a 10-minute recess.
Mr. Bauer,
Aye.
Miss Gray,
Aye.
Miss Walsh.
What is the 10-minute recess for?
So she could get caught.
So I can get caught up. That was the request. Because you guys are going back and forth, and I
Yes.
need to get the meeting minutes tight. Thank you. Latoya Burger, aye.
It is 9:22. We are at recess. We will reconvene at 9:33.
everybody copies?
I have them.
Well, there's 3.
Are we ready?
Is this what you have on? I was gonna say, I have it.
All right, it is 9:37. We have come back from recess. To note, Mrs. Walsh left the meeting during recess, and during recess, I do want to clarify that I was able to speak to our attorney just to double check. We are able to have a first read of this policy tonight, as it is germane to what is on our agenda regarding the use of cell phones and the policy regarding it. So that is within the bounds of the special meeting. So we are able to have a first read of this tonight. Goal then would be to have the second read at our July regular board meeting, and at that point we could adopt it as well.
I had one thing that before I got the update to the meeting minutes, so thank you for the recess to my colleagues. I know that Mr. Smathers had mentioned, connecting with the district safety committee as well as the board's parent advisory committee. I just want to note to our colleagues that our parent advisory committee is the day before our board meeting. So I know that policy states 48 hours. So if there's any additional input that may come within that, in less than that time frame, because our meeting is July 7th as they present, parent advisory presents at our July 8th meeting. So we did it the day before as a way for rehearsal. So I just wanted to share that with my colleagues on that. Thanks.
Is it possible, Mr. Smathers, that information that comes from the safety committee meeting be forwarded to the parent advisory committee?
Absolutely.
And that way, at least they've had an opportunity to look at that stuff.
Right.
Thank you.
Thank you.
And then maybe we should just invite them to come. So then that way they have an opportunity.
It's Wednesday. Would you be able to message them or send me the list?
Yeah, Mr. Dr. Green or Mr. Morpitzer has. I don't normally do
Okay,
communicate
all
that piece, but yes, someone could just make them aware of it at least, and then that way we can get their information in enough time to then be within the policy piece to get both the board's parent advisory committee and our district safety-wide committee's comments and share.
Okay, thank you.
All right. Any other comments regarding the cell phone policy? All right. Oh,
So this is just considered our first read, and is someone going to read it, or are we just going to just take it away as we normally would? I didn't know if there was anything that needed to be highlighted or
is there any,
comments.
Mr. Morbitzer, is there anything you'd like to let us know about regarding this?
Before we start, I would just like to ask that with this, I'm going to make sure that after this board meeting, request that this is added to our board docs, please. So then that way, if someone goes back and looks, is it on there already? I didn't see it. So this one would need to be added to board.
It's not on there already.
But we
We'll
need to
have it
add, I
added.
just want to
Yep.
make sure I make a note that we made note to add it. Thank you.
Yeah, what I want to point out is that this is consolidated. This is considering Ohio Revised Code, guidance by the Department of Education, board policy sample provided by OSBA, also in consideration of other school district policies. I did have a chance to look over the Akron City Schools policy. There are some things that are of merit in that policy that we may want to consider in our second read, because what I have put together for you is I think it pertains to every part of the discussion and the questions that the board had just a little while ago during this meeting. I think it's pretty comprehensive, but I do think it stands to reason that we could add some things to it from some other policies. I do want to point out the sections of it. There's a definition section that is consistent with Ohio Revised Code. It also includes the differentiation between personal electronic communications equipment, which includes a cell phone, and personal electronic devices, which do not necessarily have the ability to communicate. School building, school day, and school grounds, like I had said earlier, are also defined here. And then when you look at the next section, it says personal electronics communication equipment and PEDs that are governed by this policy include but are not limited to. As I talked about earlier, I've taken out the specific references to brands. We do not promote brands. We don't need to. We can still refer to those devices as to what they are without including that specific information about the branding. In bold, it says students are prohibited from using any of the personal electronics devices and PEDs listed above during the school day. I already see that that should include the personal communication equipment rather than, it may be correct on yours. Yeah, I think it might be, but it has to be changed to personal electronics communication equipment and PEDs listed above during the school day. And then it goes on to explain when those can be used and the different circumstances when they can be used and they cannot be used. But again, I think it suffices as a first read, and it's probably needs to be added to with some specifics from some other sources.
I have a question. Has this been when after this? Can we get this over to legal?
Certainly.
Make sure. I didn't know if this one had already been through.
Has not. No.
Okay, so that was my okay. Thank you.
You're welcome.
Any other comments?
When this goes on Word doc, I think could be a draft.
Mhm.
Because it says it's a document. The date for the document.
Right. It just has the previous information on it. It needs to be changed to draft. Yes.
Well, thank you so much, Mr. Morbitzer, for your work on this. Mr. Smathers. Mr.
You're welcome. Thank you.
Yep, thank you.
Mr. Bauer, if I can make a comment not specific to this or either policy tonight. I think we need to really assess how we're going to do policy, because in the normal update, if there are 15 or 20 policies, we spent about 3 hours tonight on 2 required policies with sample language given. We still don't have one of them approved, which is the second meeting doing that, and the first one took us about an hour and 35 minutes to get there. This is not a practical format, in my opinion, and it's, I think, dangerous to try to edit and modify policy that hasn't been reviewed by legal on the fly without doing analysis and some things like that. So I just want to express some of those concerns, because as we know, policy is very important. It's one of the primary functions of the board to do that. But I felt like we were kind of grasping to get to an answer tonight.
Duly noted, and I agree 100%. I think that this needs to be condensed more, and as a board, I think we need to be better prepared.
If I could ask, I know I mentioned in the last board meeting, and I don't know if this is something where we could have legal come or send or even get OSBA to provide any case law where, like these changes, I had specifically asked, and this is how we did it prior to this particular board. We would, if we had changes and things like that, or things we wanted to have suggested, it would all be a part of board docs and everyone would look at it prior to the board meeting. It wouldn't be we would discuss it here, but we all would have it in advance. Am I wrong? That's what we used to do. Like we did it with the handbook, we've done it with the policies. So am I wrong when I say that? I'm asking. Okay.
Questions or comments about policies were brought to the attention prior to the meeting.
And then that would be included in board docs. So then when we discuss those things, it wouldn't be we would share an email. It would go to our admin person who's managing the policies. So I think there was some confusion on the last board meeting, Mr. President, regarding what we can and can't do. And I know we've done it in the past, but I want to make sure we're in compliance. And maybe if we could get an opinion or something like that to read at our next board meeting. And as Mr. Mr. Superintendent mentioned, have that as our best practice going forward on how we manage and approve our policies.
Yeah, absolutely. Sounds good. All right, on to adjournment.
So moved.
I have Mrs. Dowdleberger as first, Mrs. Gray as second. On to roll call, please.
Ms. Gray.
Aye.
Mr. Bauer
Aye.
and Ms. Alderberger, aye.
9:47. We are adjourned.